I beg your lordship's liberty to mention this matter, my lord. My lord, I mentioned this matter last Monday.
Very
In
good.
spite the matter has not come, my lord.
Very
Though I am
good.
in fever, I am suffering fever. In spite I have come.
Very
Matter
good,
is
sir.
serious threat of demolition. Serious threat of demolition by the Asansol Municipal Corporation, alleging that factory premises is illegal. But not that, my lord. I have sanctioned plan, my lord. A lawyer's destination is to the court, my lord. In spite of that, I went to the spot, my lord, to resist them. But not by my
You
lord.
shouldn't do that.
My lord.
You shouldn't do that.
My lord.
You shouldn't do that.
No, my lord.
That's not your job.
No, my lord. Huh?
And if you think that is a ground for this court to interfere because you took the pains of going there, then I'm sorry.
My lord,
this court will not.
Only I told them that the matter is sub judice.
This court will deprecate this kind of action.
My lord, matter is pending.
Not encourage this kind of action. Your job is towards the court.
My lord.
Not go and stand in front of a property.
My lord. My lord, kindly.
If you think this argument will impress me, I'm sorry.
My lord, kindly fix this matter, my lord.
Give your slip.
My lord.
And in all probability, it will not be fixed.
My lord, kindly fix this matter. My lord, kindly fix this matter, my lord.
Don't make these kind of submissions. That you took the pains to go and stand in front of the bulldozer. Is this your job?
No, my lord.
What is your job?
My job before court, my lord.
Yes. You're putting shame to your robes.
My lord, kindly look into the matter, my lord.
Next.
My lord, upon submission, service copy, it is for upgradation, the pension matter.
Give your slip. Give your slip, sir.
Upgradation matter.
Upgradation, my lord.
Take this. Banerjee, what is it?
The building is falling down. In the monsoons, there's already a corporation order under 411. Despite that, they are not taking steps. And last week, a portion of the building has imploded. This is two in the list. But my lord, it requires some precedence. Otherwise, the lives of the occupiers will be at risk.
I have to give some laws on this, Mr. Banerjee. We have to lay down something on this. It's a problem which I'm facing.
And 412A, in fact, does not totally redress it. It's taught at portions. My lords will have to lay down an SOP.
Yes, we'll see.
Well, Lord, may I have a lordship's kindly to mention the original side matter?
What is it?
Lord, item number 35, Lord, of the Lord, supplementary list on last Thursday, Lord. Lord, construction is going on. Lord, upon the Lord, basement plus ground plus 6 to 25 years old building, without taking any consent, Lord, from the Lord, unit owners, other unit owners.
Don't mention it. Mention it on the original side day.
397, Lord.
On the original side day. Yes.
It's kindly to mention, Lord, an extremely urgent matter, Lord. I've been waiting for quite some time. This is basically on mutation, Lord, from my property. They've carved out, Lord, a property and mutated, Lord, in the name of the other side, and he started making construction.
Give Mr. Chatterjee.
Too great. Lord, any day, your lordship, please.
Give us.
Lord, family.
My lord, the shop room has been closed by the notice of closure by the municipality. My lord, the order of demolition has been challenged before the civil court. My lord, civil court stayed the order of demolition. In the meantime, no hearing was given. Notice of closure, shops has been closed.
So go before the civil court.
My lord, civil court, my lord, that there is no the order violation of the order of the civil court. They have not taken any steps before the municipality.
Give your step, we'll see.
With all humility.
Yes, Mr.
With all humility.
Yes, Mr. Yes, Mr.
But on 6th, I received a notice by which 7 days time has been given to vacate so that the corporation can proceed with demolition. I am a tenant over there for last 50 years. But I am not averse to the intention of the landlord to demolish and rebuild. Only certain modalities are there which, my lord, the honorable court has fixed. But unless those agreements and all comes up, my lord, immediately that demolition is going to prejudice me. My lord, if your lordship would kindly, with folded hands, I say, if your lordship can pick it up tomorrow at 2 p.m. I have served everyone. It's not that I want to move expertly. I have served everyone. Everyone is in the notice. Even the corporation, my other side, everyone is in the notice.
We will see, Mr. Mukherjee. Give
Original side.
give this slip. Tomorrow it can't come up. Original side matter tomorrow. Not
at the top.
Thursday, then, my lord, I'll give a notice that
Thursday.
lordship has been fixed it on Thursday and top.
Thursday.
Great.
Lord, may I have your lordship's Lord kind leave to mention, Lord, item number 2465 of your lordship's monthly list. Lord, the urgency is that, Lord, the corporation, along in collusion with the interlopers, Lord, are constructing, Lord, road on my property. Lord, despite repeated, Lord, representations, whatever, Lord,
Give
any
your
day,
slip.
Lord, subject to your lordship's
Give your slip.
convenience.
So family pension
Of like-
Navadvip municipality lordship.
Give your slip. Give your slip, madam.
Yes, my lord, may I be permitted to mention one non-prosecution, 76 years old, the petitioner, my lord.
Lord, it's a parking tender. Lord, I am protected by an interim order which is going to be expired. Report was directed to be filed within 15 days.
Parking tender, parking allotted.
Parking allotted, but they were not in a position, Lord, to give me, Lord, 70 number of vehicle space. That's why an interim order passed by this honorable court. Lord, the 15 days was the date fixed, Lord, for filing of report. Till date, no report filed. May it appear as, Lord, the extension.
We will see.
But I'm grateful.
Lordship, may I permit to mention matter for upgradation. It is listed in item number
Give your slip, sir. Give your slip.
Or may I be permitted to mention
Mr.
one
Singh.
matter, my lord? This involves the mobile towers. Now, corporation is purporting to levy property tax on
They can.
mobile.
They can.
Now, that was the provision, but now, my lord, there is a notification. The recent act, the Telecommunication Act of 2023.
The corporation, in their own wisdom, if you see the definition of building, they are entitled to lay taxes not only on the tower, but also something which is inside the ground.
Yes. Now, my lord.
That is how far the definition of building stretches.
Now, my lord, there is another act, the Telecommunication Act,
That's
which is a central act, a later act. That has clarified what is the nature of a telecommunication tower.
That's
Now,
all right.
On that basis,
This is on the basis of a structure, not on the basis of a definition of.
no, but
what?
it is a telecommunication.
Anyway, you give it, we'll see that.
Well, kindly see what they are trying to give. Now they are trying to seal the tower. Now that will result in
The law is settled, Mr. Sen.
there is some. I would like to make some submission. I don't think this act and this new day
We will see that.
considered. Kindly take it up any day convenient.
We'll see that.
Because otherwise, if you take monthly list, it is there. Item number 2464. 2464.
We'll see that.
Subject lordship kindly was mentioning about an application a pending writ petition. This is a GA. It's an urgent side matter. I mentioned this matter to lordship twice. Lordship said the matter will appear. So not any day. This Thursday, my lord is taking up the urgent side.
I never say the matter will appear.
No, I mentioned this, but your lordship said it will appear in due course. That is what.
I always take the slip.
Yes.
And then I see whether the matter is.
I mentioned twice.
Give your slip.
Would appear this Thursday, subject to my lord's kind.
Give your slip. Give your slip.
Kind permission. Then you might have to vote the matter urgent.
You sit on the scooter without a helmet.
Yes, I was with helmet. I don't have that.
Give your
That much
slip.
of awareness to avoid the law.
Good. Give your slip.
Well, it's a leave matter, my lord.
What leave?
For conducting a meeting where Shankar Ghosh was pleased to direct the police officer to give the permission. And as part of the
What meeting?
Public meeting by political party.
Why are you here?
One of the things is that Justice Shankar Ghosh was pleased to grant the permission for conducting the meeting to the.
Why are you in this bench?
The street meeting, Justice Ghosh has directed me to take the permission from the municipality.
Yes.
Ask the municipality to grant me the permission.
Yes.
By virtue of the solemn order, my lord.
What role municipality has for granting permission?
Because I am taking the street for
You
the meeting, my lord.
You want to do a street meeting?
Street meeting.
For what?
Political, I don't know what meeting, but they will organize a political meeting.
When is it?
It's in Bhatpara.
Bhatpara. When?
It's 16, my lord.
Huh?
16.
16th. During 15th August, who can give you after 15th August?
It's a free space. What the municipality stand is that I am sending it.
So go and challenge if they have rejected your, what have they done? They have given a rejection.
Just mentioned that as the name of the trade union was registered in Rajasthan.
Yes.
So the matter was forwarded to the register of trade union.
Yes.
Until and unless they will give the approval, the municipality will not permit me to conduct the meeting.
Absolutely correct.
But it's a registered.
So what? You are registered in Rajasthan.
Registered in Rajasthan.
So let them find out whether you are registered, not registered.
Kindly give the direction to.
That they will do.
I can produce each and every document that I am a national level political party.
File it, then mention it. So what? You're coming at the last minute.
Today, my lord, it will take 2 to 3 days.
File it, you come back tomorrow. File it first.
Direction to start the copy to the Bhatpara municipality.
Have you served all the copies?
No, not me. My lord, kindly serve in the Bhatpara municipality.
There is no
No,
problem.
no, first you file it, then you mention it.
File it and serve the copy.
File it, serve it, then mention.
Lordship, may I be allowed?
I'm not giving you leave to file. This is a very bad habit of seeking leave.
Number will not be provided to me as the registration number will not be.
It will come day after tomorrow. Within 2 days, it will be provided.
Lordship, may I be allowed to mention a pending matter? Your Lordship was
Yes.
pleased to fix it on 8th September.
Yes.
Your Lordship, the direction was given for demolition, Your Lordship. The respondent number 8 went up in appeal, Your Lordship, on 18th of July 2025. The Honorable Division Bench was pleased to direct the demolition within a period of 1 month, Your Lordship. The date of 1 month expires on 18th July 2025, Your Lord, 18th of August 2025. But the demolition has not been conducted yet. But here, before Your Lordship, the matter has been fixed on 8th September. Your Lordship, kindly takes it up.
There is no stay from this court. Is there a stay?
No, I am seeking demolition, Your Lordship.
Madam, the matter which is fixed on the 8th of September, is there a stay operating? Then what is the problem?
No, Your Lordship, I want the demolitions to be conducted in terms of the order of the corporation, Your Lordship.
We will see
they are
that.
not demolishing, Your Lordship.
Emergency, madam, we'll see on it.
Matter for inclusion, Your Lordship. It was in the July list, Your Lordship. It has been excluded from the August monthly list, Your Lordship.
Give us slip.
May I take mention in respect of a matter, my lord, I am a bona fide tenant on commercial basis of a premises.
Give your slip, we'll see.
My lord, may I permitted to mention, my lord?
Corporation is
My lord.
trying to oust without due process of law.
Very good. Give your slip.
Lord.
My lord, may I permitted to mention one matter, my lord?
Yes.
My lord, the original side matter, my lord, which was heard on 7th of August, my lord, and directed to pay 10 lakh rupees to the KMC, my lord. Mr. Trivedi is appearing in this matter, my lord. My lord, the only difficulty is the server or the server copy is not uploaded, my lord. If my lord,
it will be uploaded today.
My lord,
may I?
Today it will be uploaded.
My lord, আমার বাবা ব্রেন স্ট্রোকে আক্রান্ত হয়ে শয্যাশায়ী প্যারালাইজড দয়া করে একটু দেখুন কাট অফ মিউনিসিপ্যালিটি বাবাকে ডিসমিস করে দিয়েছে
ফাইল অফ পিটিশন
করা হয়েছে মান্থলি লিস্টে আছে একটু দেখুন
गिव योर स्लिप ये अपलोड नहीं हुआ अपलोड हुआ ऑर्डर Wednesday.
Wednesday. 13th.
I will prepare for the petition on it.
This is the against the order of demolition.
Yes.
This is the application, my lord. Writ application, my lord. Where, my lord, the 55-year-old residential premises, my lord, is put under the teeth of demolition, my lord, at the instance of the private respondent, my lord. If your lordship kindly puts to, my lord, the complaint which has been made by the private respondent, my lord,
This is the order of municipal authority
which has culminated, my lord,
for demolition of the unauthorized construction.
Yes.
That challenge before this court. Only the question is the value, old building or new building. That is the only question is arises. Now the cause of action
kindly comes to page number.
We will hear you. Argue. Let him argue the matter, whatever he has to say.
My lord, at page number 23, my lord, which is the complaint made by the private respondent, my lord, in the year 2009,
Yes,
my lord.
go slow.
My lord.
Page
23, my lord, which is annexure P1, my lord.
Page 26.
So this is the complaint.
My lord, this is the original complaint which has been, my lord, communicated to these proceedings, my lord.
2009.
My lord. My lord, at paragraph 2, my lord, the first paragraph is the description of the parties, my lord, which has made the complaint. My lord, paragraph 2, my lord, your lordship will find, my lord, that the above mentioned persons are my own brother and Bodhi. They creating force already captured 1/3 area of the said premises and constructing further encroachment, maximum area of premises, by showing red eyes and creating force, taking opportunity of loneliness. My lord, this is the complaint, my lord. Ultimately, my lord,
All right. Yes, then.
my lord, this for non-consideration of this complaint, my lord, a writ petition was moved. My lord, your lordship has would get the order. Next page, my lord, 25, my lord, which is the order passed in the, my lord, I'm sorry, my lord, page 29, my lord, is the order of the Honorable High Court, my lord, which is at 28/7/2010. My lord, there are two petitions on the same complaint, my lord. My lord, the latter one has been dismissed and the earlier one has been taken into consideration by this Honorable Court on 28/7/2010. It is at page 29, my lord. The order of this Honorable Court, my lord.
Yes, sir.
Matter
what was the order which was passed on page 25?
My lord, this is the order of the chairman, my lord. My lord, page 29 is the order of this Honorable Court, my lord.
What
which
is
is
the
saying
order passed by the chairman? First, you show me.
My lord, it is 25, my lord. This was the order of consideration by the municipality after the order of the Honorable Court, my lord. My lord, at page 27A, my lord. My lord, the relevant paragraph, my lord, over which, my lord, the corporation has held, the municipality has held, my lord, that it's a private complaint. It is further appears that the parties are residing at the same premises and the same premises is undivided and joint one. The dispute is raised in the case is a private dispute. And since there is no partition or demarcation of premises, it is very difficult to ascertain the nature of violation since the dispute is private and civil in nature. And the same can be settled and disposed of with the intervention of the competent civil court. Being aggrieved,
Being aggrieved, they went to?
My lord, this was the order.
Yes.
It was the observation, my lord, by the then municipal chairman, my lord. When
Yes.
having agreed, my lord, another writ petition has been filed. My lord.
Yes.
That your lordship would get at page, my lord. 33, my lord. P3.
Time killing.
Yes.
My lord, there, my lord, this coordinate bench of this court, my lord, has sent this matter to the municipality, my lord, for an initiation of 218 proceeding, my lord. Since my lord, chairman has passed that order, that was not maintainable. That was no stand in the eye of law. 218 has been, my lord, directed to have been initiated.
Petition fail করেছে
The last paragraph, my lord, your lordship will find, my lord.
Petition fail করেছে
For this reason, I dispose of the writ petition ordering as follows. The impugned order dated 10th May 2011 of the chairman of the municipality is hereby set aside. The Board of Council of the municipality is directed to register section 218 case and decide it after making necessary inquiry. Recording proceedings and hearing all concerned as expeditiously as possible. Oral prayer to add Board of Councillor as my lord. In this proceeding, my lord, in this writ proceeding, my lord, I was not represented. Perhaps, my lord, no notice was given, my lord, no affidavit of service has been there, my lord. My representation was not there in that writ proceeding, my lord. Had it been so, it would have been, my lord, submission was made to have been, my lord, the private rivalry and all that, my lord. My lord, what happened next, my lord? At page 35, my lord, a reasoned order has been passed by the, my lord, in 2017. My lord, that order, the order of this honorable court was in 2013, but they, my lord, on 2017, since, my lord, the Vidhannagar Municipal Corporation has came into effect, my lord, and, my lord, the area of the premises, my lord, has been included in 2015 only. So, my lord, the municipal corporation has passed a reasoned order, my lord, directing, my lord, demolition
You are Rupa Das Gupta?
No, my lord.
Kanika Chaudhary?
My lord, I am the Konika Chaudhary, my lord.
You also appeared?
My lord.
You had appeared?
No, here I didn't appear, my lord.
Page 37?
My lord, the municipal authority, before the municipal authority, I appeared.
Yes. So what are you saying?
My lord, the order over which the municipal authority take into consideration, the order on which.
What order?
My lord,
page 37, see the order.
My lord, 33, page 33, my lord. Page 33, my lord.
Lord,
The order of this honorable court, over which the municipal didn't take into action.
It doesn't matter.
My lord.
You appeared before the municipality.
My lord,
you are saying you didn't appear before the honorable court, high court.
Honorable court, my lord.
How does it make a difference, sir?
My lord,
you were given a hearing before the order is passed.
All along, my allegation
will
is
kindly come to page 60. The
My lord,
case at present is at page 60.
Yes.
Thereafter, my lord, the writ petition was moved against the order of demolition, my lord.
Page 60.
Page 60, 60. My lord, all these things are passed. Now, upon the orders, we have passed a reasoned order.
What had happened?
This is the second order of demolition. The first order of demolition was in respect of the 2 rooms on the first floor. My lord, the second order of demolition is for the entire premises.
No.
My lord. My lord, at page 59.
Just a minute.
First order of demolition was set aside by this coordinate bench.
So what was the need to pass the second order on page 60?
Milord, there was a direction of Justice Amrita Sinha, Milord, on 17th.
Which page?
Milord, page 60, it is mentioned, Milord.
No, but where's the direction? It's here.
Milord, I'm just.
My lord, at page 50, my lord.
50.
Page 48 it starts.
My lord, it starts
What
from
did
50,
the
my lord.
challenge before Justice Sinha?
My lord, the first order of demolition, my lord, which has been passed in respect of 2 rooms in the first floor. My lord, that has originated from the complaint of encroachment, my lord. My lord, the municipality, at its wisdom, my lord, earlier ordered, my lord, earlier declared, my lord, it is a private dispute. There cannot be any.
ফার্স্ট ডেমোলিশন অর্ডার ছিল রাজারহাট কোর্টে, সেটাকে চ্যালেঞ্জ করে সেকেন্ড রাউন্ডে ঠিক আছে। তার জন্য 60 কে যে কনফিউশন ছিল সেটা হচ্ছে
দেখিনি দেখিনি
নিজে দেখি দেখিনি
আমরা অলরেডি বলেছি যে ইজ ওল্ড ইজ নিউ।
হ্যাঁ কতটা
সেটা তো প্রশ্ন নয়।
সব বলা আছে, অর্ডারে সব বলা আছে, চলে যাচ্ছে অর্ডারের সব বলা আছে।
তখন দেখতে আছে
All right. After that, Justice Sinha's order is.
After Justice Sinha's order, Milord will kindly see page 54. 54 is the hearing notice, and page 55, Milord, is the inspection report which has been supplied through page 54 to all parties. Milord, the inspection report says there exists 2-storied building in the alleged plot. Ground floor is old construction, but a portion of the first floor is newly constructed. No sanction plan could be produced by the occupiers to justify approval of the authorized construction of the building. After this, Milord, there are few written submissions on behalf of Konika Chaudhary and all. Now, Milord will come to page 60. Milord, from page 60, the order starts, Milord, with the submissions and all. It comes up to page 64. At page 64, Milord, Milord?
Yes.
Page 64, Milord, we found out an issue which says that whether there is any unauthorized structure erected in the plot of land comprising of such and such, which is the plot of land concerned, Milord, within the limits of the Bidhannagar Municipal Corporation or not. Now, Milord, the decision with reasons, Milord. Well, may I please, Milord?
Yes.
At page
After
65.
taking into consideration all submissions made by all concerned parties and in the light of the legal provision, it appears that save and except the above mentioned submission, the petitioner and all concerned parties have given their final submission and have not raised any point and or discrepancy in this matter. That the opportunity of hearing was given to the concerned parties with due notice, and inspection of the same premises was conducted on the 16th of October 2023 in respect in the presence of both petitioner and the private respondents. As per the inspection report, the observations are that there exists 2-storied building. Ground floor is old, but the portion of the first floor is newly constructed. No sanction plan could be produced by the occupiers to justify the approval of the unauthorized construction of the building, authorized construction of the building. that no plan was produced at the time of inspection or at the time of hearing. It is contended by both the parties that the structure was built by one Shochindralal Chaudhuri as owner of the plot and later by means of inheritance and gift devolved between the petitioner and the respondent respectively. Alleged Konika Chaudhuri seems to have made some addition on the first floor of the structure, that the structure has been constructed in the absence of any sanctioned building plan from appropriate authority. That it also appears that that erection of structure building without any sanctioned building plan and without prior permission from the municipal body is gross violation of the West Bengal Municipal Corporation Act, that neither the petitioner nor the respondent is able to produce this sanctioned building plan, and the dispute remains as to when the structure was erected. That in the absence of any building plan, whether issued by the Gram Panchayat, RGM means Raiganj, Rajarhat Gopalpur municipality, or BMC, as the case may be, and during tenure of which law in force and any unauthorized structure cannot be allowed and is subject to appropriate order for demolition. That no application for addition or repair of buildings under section 262B of the Corporation Act was ever made. That both parties have failed to produce any sanctioned building plan, and in the absence of the same, the authority is bound to pass necessary order under section 266 of the Act. Under the facts and circumstances, the undersigned directs Rupa Dasgupta and Konika Chaudhuri to demolish the unauthorized structure erected from the plinth level, erected without any valid sanction plan within 4 weeks from the receipt of this order, failing which the corporation will be compelled to take appropriate steps without any further reference as per provisions of the relevant rules and acts to demolish the unauthorized structure and to recover the expenses of the demolition from them as per the provisions of the Act. All concerned may be informed accordingly.
Now, my lord, my humble submission would be before your lordship, my lord. My lord, according to my lord, the observation made in the recent order, my lord, your lordship has seen page 65, my lord, paragraph 3. My lord, as per the inspection report, the observation as follows. My lord, the observation is that, my lord, the Roman 2, my lord, the ground floor is old construction. Yes. But a portion of the first floor is newly constructed. My lord, the facts remains, my lord, according to me, my lord, according to the, my lord, the read petitioner, the building was constructed, premises was constructed by the father of the private respondent and the father-in-law of the read petitioner in 1970, my lord, before 1970. My lord, and the first floor 2 rooms was constructed in 1990. My lord, in 1990, if it is so, my lord, according to the read petitioner, this cannot be said to be new construction by the Act itself, my lord. My lord, the definition of new construction as well as section 3.
This is additional construction, sir, not reconstruction.
New one, my lord, it is stated that it is new construction.
Yes.
My lord, according to the Act, my lord, this cannot be said to be new construction. New construction would be, my lord, according to section, my lord, if it is commenced after the inception of the Act, my lord, according to the definition, my lord. So, my lord, it cannot be new construction. According to me, it has been constructed in 1990. My lord, I have in supplemented affidavit, my lord, yes. I have, my lord, produced one deed, my lord.
Yes.
There your lordship would find, my lord, your lordship kindly takes up, my lord. My lord. My lord, my supplemented affidavit, my lord. It is at page, my lord. Yes. 26, my lord. At page 26, my lord. There is a deed, my lord, by which, my lord, the read petitioner had got, my lord, the 1/4 share of the premises. Vis-a-vis, my lord, the private respondent has got 1/4 share of the premises. My lord, out of that, my lord, the property has been owned 50-50 by myself and the private respondent, my lord. My lord, this is the deed by which, my lord, I have got 1/4 share from my sister. My lord, there your lordship would find this is of 2008, my lord. The document is of 2008, my lord. There your lordship would find one plan, my lord. At page No, 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 no. No, no. At page 36, my lord. At page 36. This is the site plan annexed to the deed, my lord, which has been registered in 2008. There you also would find, my lord, at the left-hand side, my lord, the box, my lord. At the left-hand side of the box, my lord, the existing ground floor residential building, 40 years old building. And, my lord, at the right-hand side, my lord, box, my lord, you'll also would find, my lord, at the middle, my lord, it is existing first floor residential building of, my lord, 15 years old. My lord, in 2018, the first floor was of 15 years old, according to, my lord.
Who all are making these 40-year-old, 50-year-old?
My lord, this is the surveyor of the municipality. You also would get at the bottom, my lord,
Yes.
the numbers and the registration numbers of the surveyor, my lord, registered surveyor of the municipality.
How do they know it's 40 years old or 50 years old?
My lord, that is the plan, my lord, usually to be produced with the.
Where is your plan? If you have a plan, then the entire issue goes.
My lord, it was not made by me, my lord. It was made by the father-in-law of the petitioner. I came into the property in 1997 after getting marriage. My lord, it was built by the father of the private respondent and the father-in-law of this petitioner, my lord. My lord, I am nowhere at that point of time. My lord, it is not that the.
And what action
I
have you
couldn't
taken
produce,
against the petitioner? In the first, not here. The petitioner who had made a complaint because the entire building, his and hers, both, must be illegal.
That is what we have said. Milord, it is both of them who has to demolish whatever is there beyond the plinth. Whatever we have found unauthorized, whoever owns it, they have to demolish. And Milord will see page 66. Our direction is upon both, upon Rupa Dasgupta as well as Konika Chaudhary. Rupa Dasgupta is the private respondent.
Yes.
The direction is not upon one. It might be, Milord, the Rupa Dasgupta is not getting affected.
My lord, after residing the premises since her childhood, my lord, the complaint has come by the private respondent, my lord, that it is a unauthorized construction, my lord.
Yes.
No plan has been sanctioned. My lord, all along, my lord, it's a rivalry, my lord. It has been held by the earlier municipality, my lord, as also by this court, my lord. My lord, my humble submission would be, my lord, this is residential building, my lord. This is not a high-rise construction by any promotion or otherwise, my lord. My lord, the residential construction, my lord, has got some exceptions, my lord.
Show me, sir. When you are making submission, show me. I never knew that in law, residential buildings have an exceptional or a different category if they are unauthorized.
My lord.
Any building which doesn't have any sanction plan or it's illegal has the same status, whether it is multi-storied or a residential building.
My lord,
if you have a separate judgment to show that residential buildings constructed illegally can remain, show it to me.
No, my lord, no separate judgment, my lord. But my lord, for the purpose of mere diffraction, my lord, only the sanction plan of old construction, my lord, whether, my lord, the other requirement of the my lord, the building laws doesn't violate, my lord. If the portion which has been created, which has been left open, whether the other requirements under the law, my lord, has been followed or not. Only the construction plan, my lord, is not there with me, my lord. Since I was not there, I couldn't produce. It cannot be said, my lord, no building plan was there. My lord, the record of the corporation doesn't say, my lord. There was.
That's what they say.
Record is not found, my lord.
There is no building plan.
My lord, record is not found, my lord. It is only submission from the authority, my lord. They couldn't produce any record. I have, my lord, tried to find out from record, my lord. They are saying no record is found. My lord, in my RTI, they have said, my lord, there is no record in respect of that. My lord, I will be relying on one decision, my lord, is of old, very old, my lord. But kindly consider. Kindly consider, my lord. Well, kindly consider, my lord, it is of 1995, supplementary 4, SCC 426, my lord. My lord, kindly. Sir.
Yes.
My lord, on the next page, my lord, may I come to relevant one, my lord, state by my lord. On the next page, my lord, paragraph number 4, my lord. However, my lord, it is stated, my lord, it is ordered, my lord, it is to be found out that the mere departure from the authorized plan or putting up a construction without sanction doesn't ipso facto, my lord, or without more necessarily and inevitably justify demolition of the structure. There are cases of such unauthorized construction. Some are amenable to compounding or some may not. There may be cases of grave and serious breaches of licensing provisions or building regulations that may call for extreme step of demolition. These are the matters for authorities to consider at the appropriate time, having regard to the nature of the transgression. It is open to the petitioner to move the authority for such relief as may be available to them at law. The petitioner may, if so advised, file a plan indicating the nature and extent of the unauthorized construction carried out and seek regularization. My lord, the regularization I couldn't as yet, my lord, because my lord, the demolition is on the hearts, my lord, on my head, my lord. I have to protect it first, my lord. My lord, if your lordship kindly, my lord, allows me leave, my lord.
Why are you making this kind of submission? Third round of litigation.
My lord, it is not the third round, my lord. It is the sixth round, my lord. Fourth round has been
much better. Sixth round of litigation.
My lord, fourth round by the private respondent, my lord, and it has failed. Having ended in smoke, my lord, the first order of demolition, the private respondent has taken the steps, stand, my lord, the entire building is unauthorized. My lord, thereafter this observation has come, my lord.
Will you hear the court?
My lord.
Will you hear the court?
My lord, always. My lord.
You are saying that you didn't get the time to make a regulation application,
my lord,
for the last 30 years.
My lord, in 2017, at order of demolition, my lord, I had been.
So who was stopping you from applying for regulation of the building? If you at all you are permissible to do it, whether they have a policy or they don't have, I don't know.
My lord, perhaps my lord, the petitioner was not advised to do so, my lord. That is the reason, my lord. Perhaps, my lord. I am before your lordship, my lord. I am before your lordship, my lord. Your lordship may consider, my lord.
What else?
My lord, it is of 2001 4 SCC, my lord, into 215, my lord. My lord, kindly. Well, here is also, my lord. At state of my lord, kindly take up paragraph 11, my lord. Kindly, my lord. It is once again, my lord, the regulation can be granted, my lord.
So these are not applicable for you.
If it is so, my lord, I may be given an opportunity, my lord. It is of my lord, 54 years old, my lord.
You could have done it earlier.
My lord, it is of 54 years old, my lord. It was not done by me, by my father-in-law, my lord. My lord, I am in a dilemma. I am in a difficult position, my lord, to protect my matrimonial home.
Very good.
Well, had it been the case, the petitioner would have, the private respondent would have restrained from at that point of time when the construction was made. She didn't do so, my lord.
Who else is there?
I would have been saved there.
Anybody for private respondent? Yes. What do you have to say? Yes. Any argument?
No, my
Yes, Mr. Nag. Anything else?
But I cannot travel beyond the reasoned order, my lord. We have filed a affidavit in opposition saying the same thing, my lord. Lastly, this matter was referred to mediation, which it appears that mediation has failed.
Mediation failed, no?
It appears. I was not a party.
My lord, in the supplemented affidavit, I have annexed, my lord, 2 representations during the mediation, my lord. My lord, therein, my lord, the private respondent has sought for 10 lakhs rupees to relieve, to exonerate me from encroachment, my lord. Only 10 lakhs rupees she has asked for from me. He will be relieved I will be relieved from encroachment.
Lord,
that was the stand taken by the private respondent in the mediation, my lord.
The
I
difficulty
have annexed that.
It is a private dispute. They have involved us, and now is this in it.
But I guess the private respondent is not living in the property. The private respondent is
No,
there.
my lord, he is decided elsewhere, my lord.
The
My lord,
ground
with saying,
name appears to be for the
my lord,
private.
with saying, my lord, with
Right.
saying, I do not say, my lord, because this is not in the writ petition, my lord. With saying that she will be returning after 2 years when the property will be promoted, gets developed, my lord. With this saying, she has left the place, my lord. I do not say, my lord.
There's nothing in your petition also. Anyway.
My lord, I have taken the ground, my lord. There's that, my lord, certain part, some persons are behind the screen, my lord.
Very
I've stayed in the ground, my lord.
Some persons are always behind something.
My lord, if it fails, my lord, it would be a catastrophic effect, my lord. Because
it will fail.
My lord, in that event, my lord, there will be several property which will be demolished on the ground of that, my lord. Old
Should
property.
be demolished, sir. Any
Old
property. You have not proved it's an old property.
My lord, I have.
What have you put? 2007.
My lord, all along it was by stand, my lord, before
Only
the
stand.
municipality.
What document have you placed on record?
My lord, I have got the registered deed, my lord.
Registered deed of what? 2007?
2008, my lord.
2008.
My lord,
that's old property. 2008 property becomes old property.
My lord, this was prepared before the litigation starts, my lord. It cannot be said, my lord, with my humble submission, my lord, it has been prepared for the purpose of this litigation, my lord.
Very good.
Kindly consider that also.
Everything will be considered.
It was
next
prior to the litigation, my lord.
Heard, CAV.
Please to CAV.
I have too many facts to dictate in the court. It will take.
I have deeply bloated.
Item number 3, I beg to clear for the petitioner. My lord, item number 3 to 10, my lord, all are identical matters.
Yes.
My lord, only I beg to not to proceed with item number 10 because yesterday only I got the news that the petitioner has expired, passed away. So I'll have to take necessary steps upon leave of
What
your
about item
lordship.
3?
Item number 3, my lord,
Only in 10 the petition has
Only in
passed
10.
away. What is the status of item
My
number
lord,
3?
in item number 3, my lord, the petitioner before your lordship, my lord,
Yes.
is a casual employee before in the Raiganj municipality.
Yes.
The petitioner, my lord, was inducted at a time, my lord, when there was no recruitment rules, my lord. Now, my lord, thereafter, since there was no recruitment rules and I was appointed at that point of time, I filed a petition before this honorable court and the principal secretary was directed to consider it. And the principal secretary passed a reasoned order. I was aggrieved by the reasoned order, so I have come up before your lordship. Now, my lord, my prayer is for regularization in service. In the meantime, my lord, and in absolutely in 6 identical matters, an order has been passed by the Honorable Justice Rajoshi Bharadwaj directing immediate regularization. Those persons, my lord, I believe my learned friend will agree, those persons stand on the same footing. They were also they were also recruited at a point of time when these recruitment rules were not in force. First. Second, my lord, reliance was placed upon by me and my lord Honorable Justice Rajoshi Bharadwaj, my lord, was pleased to accept that submission also. I placed reliance upon Jaggo versus Union of India and my lord, I placed reliance upon one order of this honorable court, a division bench order of this honorable court, whereby of the same municipality, Raiganj municipality, 13 posts were created because those persons were also not appointed at a time when there were no recruitment rules in vogue. So, my lord, if your lordship allows me to place these judgments before your lordship,
yes.
The order passed by the Honorable Justice Rajoshi Bharadwaj I have placed before your lordship. If your lordship kindly... Oh, আপনারা জানেন না?
Who are you appearing for?
I am for the state, my lord.
Nothing to do. Yes, you?
No, he is along with me.
Mr. Bandyopadhyay is...
For the municipality.
You are the answering correspondent.
Order has been passed by the state authorities.
Give a copy. We were appearing for
No,
the.
he
We were
was appearing. Mr. Bandyopadhyay was appearing.
for the municipality.
for
We
the
appeared in
matter.
the hearing also before the principal secretary. But today the order challenge is by
It is,
Mr. Mahato will defend it.
My lord.
Now, possibly, if my learned senior friend has not have a copy of this, it is order টা আপনার কাছে নেই?
WP number.
WP number, my lord,
Give a
I'll
copy.
have to give a copy. তোমার কাছে আছে কপিটা এটা?
না বার করতে হবে।
বলো তুমি বলো।
WPA 719 of 2020. 6 matters were taken up together, my lord.
Yes. WhatsApp করে দিতে হবে।
জজ সাহেবকে দিয়েছি।
WPA
জানতাম না ওনাদের কাছে নেই।
719
719 of 2020. স্যার এদিকে এসে দেখুন না। My lord, my lord, the relevant paragraphs, if your lordship kindly allows me, are from paragraph 25, my lord. The operative portion starts from here. If your lordship allows me to read it, possibly my learned senior friend will also be able to. Having heard the learned counsel for the parties and perusal of the records, this court is of the view that the core issue in the writ petitions is whether the petitioners who have rendered over decades of continuous uninterrupted service in Raiganj municipality against vacant and necessary posts, albeit without formal regularization, are entitled to be absorbed into service on a regular basis, especially in light of their long-standing engagement, institutional recommendations, and judicial precedents on regularization of casual employees. This court notes that the petitioners were engaged not in a clandestine or illegal manner, but pursuant to a formal resolution of the Board of Councillors of the municipality. Here also they were engaged on a resolution of the Board of Councillors. Their appointments were made in response to acute administrative exigency and a shortage of municipal staff. At the relevant time, that is prior to 12/9/2006, the West Bengal Municipality Employees Recruitment Rules 2005 had not yet come into force. Therefore, there were no codified service rules or prescribed procedure for appointment to municipal posts. The distinction between illegal and irregular appointments as laid down by the Honorable Supreme Court in State of Karnataka versus Umadevi reported in 2006 4 SCC 1 is crucial. The court emphasized that while appointments made in violation of constitutional mandates, that is without sanctioned posts or due process, are illegal and not eligible for regularization, appointments made irregularly, such as without approval but against vacant posts and under bona fide exigencies, which may be regularized based on long uninterrupted service. In the present case, the appointments were not contrary to any prevailing service rules, as no rules existed at that time and were made transparently by the statutory authority. Thus, the petitioner's appointments at best may be termed irregular but not illegal. This court finds compelling parallels with the division bench decision in Prashanto Kumar Das Supra, wherein the Honorable Court directed the creation of sanctioned posts and regularization of similarly placed workers in Raiganj municipality who had been appointed under similar circumstances. It was held therein that in the absence of recruitment rules at the time of initial engagement and in view of long-standing service under official sanction, the engagement could not be termed illegal. The said judgment has not been overturned and has been implemented by the creation of 13 sanctioned posts and the subsequent regularization of those petitioners. The petitioner's legitimate expectation is also reinforced by consistent actions and communication issued by the municipality per se from 2017 to 2019, requesting the director of local bodies to approve their regularization. At no point was any adverse order passed by the state government or the director against the petitioner's continuation. The director's letter dated 6/7/2018 even advised initiation of the process if needed for regularization. The recruitment notice dated 28/12/2019, which seeks to fill the said posts occupied by the petitioners, has been stayed by this court with a order dated 21/1/2020, and no appeal or review has been preferred against such interim order. Further, the said notice was issued by the chairman of the municipality in violation of the settled law that recruitment to municipality posts is to be conducted only by the West Bengal Municipal Service Commission. Reliance is also placed on the recent judgment of the Supreme Court in Jaggo versus Union of India Supra, where the apex court held that sustained an essential service over long periods by workers, even if initially engaged without a formal process, cannot be brushed aside. Such workers are entitled to regularization and their roles cannot be dismissed as irregular or insignificant. The Honorable Court reaffirmed the humanitarian and constitutional need to distinguish genuine long-serving employees from backdoor entrants. Additionally, the courts in Narendra Kumar Tiwari Supra cautions against the exploitative practice of indefinitely continuing irregular appointments and then terminating them on technical grounds. The court therein affirmed that where appointments were made in the interest of administration, their long-standing nature transforms the employment into a legitimate service claim. It is also relevant to note that there is no evidence or pleading by the respondents suggesting the petitioners were ever disengaged, faced departmental action, or perform their duties in a manner unsatisfactory. Their continuous retention and reliance by the municipality only confirm the need for and the merit in their services. For the foregoing reasons, the petitioners' appointments were not illegal, but at most procedurally irregular, having been made at a time when no formal recruitment framework was in place. Their long and uninterrupted service, spanning nearly 2 decades in performing essential municipal functions, combined with the repeated recommendations and affirmations by the competent municipal authorities, clearly establishes a case of legitimate expectation for regularization. The constitutional goal of fairness in public employment, as embodied in Article 14 of the constitutional mandates that such employees cannot be arbitrarily casted away without due consideration of their bona fide contributions. The doctrine of equality, read in conjunction with the judicially recognized distinction between illegal and irregular appointments, fully supports the regularization of the petitioners in the present factual context, as has already been directed in similarly placed matters by coordinate benches of this Honorable Court. Accordingly, this court holds that the petitioner's employment is to be regularized with immediate effect. Now, my lord, what I humbly beg to submit before your lordship is that the only difference in this case is that the persons before your lordships, they had to approach the court once, my lord, because our representations were never taken into consideration. And when the recent order was passed, my lord, the recent order did not consider 2 aspects, my lord. First, my lord, there was a direction by the Honorable Justice Shampa Sarkar that whether that division bench order, my lord, what I tried to apprise of before your lordship, is applicable in this case. According to the principal secretary, to the authority concerned, it was not applicable, but it was not taken into consideration that it was passed at a time, these persons were engaged at a time when there was no recruitment rules. And second, my lord, the Honorable Justice Shampa Sarkar also I'll place before your lordship and your lordship also directed to see to it whether a scheme can be formulated for Raiganj municipality, because there are so many persons who have been who have been engaged as casual workers and who have been working for decades. And that apart, my lord, that was also not considered. And there are other aspects also. But what I beg to place humbly before your lordship, now that as his lordship, Honorable Justice Rajarshi Bharadwaj has held in his lordship solemn order, my lord, I beg to beg before your lordship, if your lordship kindly considers it, they're absolutely similarly placed situated persons engaged at a time when there was no recruitment rules, their service was never discontinued, they were engaged at a time when there was a dearth of employees working as Group D employees in Raiganj municipality. This Raiganj municipality considered created 13 posts and one even another post after had given post approval, post facto approval upon order of a honorable coordinate bench. Another person, rather 14 posts were created, 13 plus 1 thereafter posts were created. This same Raiganj municipality. And this also pertains to same Raiganj municipality, this order of Honorable Justice Rajarshi Bharadwaj. And if your lordship also considers Jaggo versus Union of India, that my lord knows much better than me, that has directed that no person like this, even if they are part-time persons and who are doing perennial nature of work and whose nature of work is absolutely essential in our day-to-day life, they cannot be ousted like this. So my humble submission before your lordship, my lord, if your lordship they have made a prayer for regularization and for a prayer has been made for quashing the recent order.
Yes.
My lord, so far as
my lord, in this matter, my lord, I am defending the order of the principal secretary. My lord, the order has not been placed, my learned friend. It has been details and reasoned order.
You can place it, sir.
My lord, I can place this, my lord.
We'll have it after lunch. You place your.
My lord.
After lunch.
My lord, input judgment at page 65
Yes.
of the writ petition. May I place the in the instant case, the Honorable High Court was pleased to pass an order on 27th July 2021 directing inter alia the Principal Secretary, Department of Urban Development and Municipal Affairs, Government of West Bengal, the respondent number 1, that having heard rival contention of the party, this court is of the opinion that it is for the employer to decide whether the case of the petitioner is similar to those persons who were given benefit in AST number 242 of 2014, that is the division bench judgment, or not, and whether the decision of the Honorable Division Bench and the decision of the Honorable Apex Court in the matter of Narendra Kumar Tewari and others versus State of Jharkhand and others, reported in 2018 8 Supreme Court cases 238, would be applicable in case of the petitioner. The fact and circumstances on which the petitioner has sought for regularization has to be decided by the authority itself. Under the circumstances, the writ petition is disposed of with a direction upon the petitioner to make a composite representation before the Principal Secretary, Department of Municipal Affairs, Government of West Bengal. If such application is made, the Principal Secretary shall consider the grievances of the petitioner in accordance with law by taking into consideration the decision of the Honorable Division Bench of this Court in AST number 242 of 2014, on the basis of which 13 posts were created by the Raiganj municipality for absorption regularization of the petitioners therein. In the Raiganj municipality, the authority will also take into consideration whether as one-time measure of scheme could be floated for regularization of casual workers of Raiganj municipality whose services have been used for long period of time even after coming into force of the recruitment rules. The petitioner made a composite representation on 6th August 2021 before the Principal Secretary, Department of Urban Development and Municipal Affairs, Government of West Bengal. In compliance with the order of the Honorable High Court dated 27th July 2021, a hearing arranged in the chamber of the Principal Secretary, Urban and Municipal Affairs, Department, Government of West Bengal on 14th September 2021. And notice in this regard was issued to the petitioner, Raiganj Municipality and Director of Local Body, with the request to attend the said hearing with all relevant documents. One, Sri Niladri Sahar, Landed Advocate, and Srimati Susmita Sahato, Landed Advocate, represented the petitioner, Sri Bablu Rajbor. Sandeep Biswas, Chairman, Raiganj Municipality, with their Landed Advocate, Mr. Orko Kumar Nag, attended the hearing, and Mr. Shobhan Mullik, Joint Director of Local Bodies, West Bengal, was also present in the hearing. At the onset of the hearing, the petitioner contended inter alia that he was engaged by Raiganj Municipality on a fixed pay of rupees 1700 per month with effect from 1st March 2006. I'll kindly take the note of the date. Filed memo number such and such dated 28th February 2006. The petitioner joined the post on 1st March 2006. He was assigned the duty equivalent to Group D, and he is still working at Raiganj Municipality against a fixed pay. He was therefore paid for regularization in service under the Raiganj Municipality against a regular Group D vacancy. The representative of the Raiganj Municipality submitted inter alia that the petitioner, now working as unskilled laborer under contractor, was engaged under the Raiganj Municipality on fixed pay of rupees 1700 per month with effect from 1st March 2026 until further order, vide memo number dated such and such. In the said engagement, it was stated that he would perform his duty under the supervision of sanitary inspector, Raiganj municipality. He was not against any sanctioned vacant post, and his remuneration was paid from the fund of the municipality. My lord, first point of my lord, taken that he was not engaged against a sanctioned vacant post. Kindly, my lord, remember it. The representative of the director of local body West Bengal submitted inter alia A, as per subsection 3 of section 54 of the West Bengal Municipal Act 1993, amended in 2022, the appointment of all other officers and employees shall be made by the municipality with prior approval of the state government. In this instance, there is no such prior approval. In the instant case, no prior approval of engagement of the petitioner was sought for or obtained from the government. The engagement of the petitioner was made on pick and choose basis without following any recruitment procedure. The judgment passed by the Honorable Division Bench of Calcutta High Court AST 2042 of 2014 is not applicable in the matter, as the engagement of the petitioner was in that case were made in between 1983 and 1985. That is, my lord, I am remember that the Uma Devi's case.
Yes.
Before there is a cut-off date of 10 years service of the municipality. Before passing of the order. Prior to introduction of the West Bengal Municipal Act 1993, the service of the petitioner cannot be regularized in view of the circular issued by the Chief Secretary by memo number 1518 such and such December 2009, conveying the direction upon the government of West Bengal in WPST 183 of 2009, Rabindranath Ghosh such and such. In the said order dated 24th August 2009, the Honorable Court was pleased to, Honorable High Court was pleased to direct inter alia not to give effect to the instruction of the Labour Department as communicated by their memo number such and such, dated such and such, for regularization stroke absorption of casual appointment or ad hoc appointees. Now, my lord, the findings. On examination of the available documents, submitted papers of the petitioner, Rajganj Municipality, Director of Local Bodies, West Bengal, it may be stated that the petitioner was engaged as unskilled labor under contractor under Rajganj Municipality on fixed pay of rupees per month from 1st March 2006. He was working and until further order of such and such, dated such and such. He is still working as a casual worker till date. As per subsection 3 of section 54 of the West Bengal Municipal Act 1993, amended in 2002, the appointment of all other officers and the employees shall be made by the municipality with prior approval of the state government. In case of engagement of the petitioner, no prior approval was sought for or obtained from the state government. The remuneration of the petitioner is being paid by the Rajganj municipality absolutely from their own fund. The state government has no contribution towards their remuneration. The initial engagement of the petitioner was done against unsanctioned post without approval of the state government. Therefore, his engagement was not irregular but illegal. His appointment was illegal, not irregular. Hence, the engagement of the petitioner by Rajganj municipality against the unsanctioned post is not in consonance with the ratio of the decision laid down by the Honorable Supreme Court of India in Uma Devi 3 cases.
Yes.
Now, in case of the Secretary versus State of Karnataka, Umadevi versus such and such, the apex court was pleased that to direct the irregular appointment could be considered for regularization at one time measure, but illegal appointment may not be regularized. In paragraph 53 of the said judgment, it has been stated that one-time exercise should consider all daily wages ad hoc of those employees who had put in 10 years continuous service.
Yes.
As on 10/4/2006. His appointment is only 1st March 2006. So the question of 10 years prior service cannot and does not arise in the case of the petitioner. My lord, the paragraph 53 has been reproduced. My lord, next page, my lord. Page 67. The Chief Secretary, Government of West Bengal, by memo number such and such, conveyed the direction upon the Government of West Bengal held in WPST number 403/2009 in the matter of Rabindranath Ghosh and such, delivered by the Honorable Division Bench, High Court, Calcutta, in its order dated 24th August 2009, not to give effect to the instruction of the Labour Department as communicated by memo number such and such, dated 13th March 1996 for regularization / observation of casual appointees or ad hoc appointees. It appears from the representation of the petitioner, he was engaged as an unskilled labor worker under the Raiganj municipality, engaged in 1st March 2006. But as per order of 100 EMP dated 13 March 1996 issued by the Labour Department, Government of the appointing authority in any establishment of the state government cannot engage casual worker without prior concurrence of the Labour Department and Finance Department, apart from memo number such and such dated 22nd January 1997 of the Director of Local Body and ex officio Joint Secretary under the department, engagement of the casual worker in urban local bodies without approval of the state government is barred. As again, per order of such and such dated department, it is amply clear that no appointment can be made by any municipality without prior sanction from the state government in municipal affairs department. Now the urban, this is now urban department. The petitioner has relied upon an order of the Honorable Division Bench of the High Court dated 29th January 2000 AST. My lord, that has my judgment has relied upon, and the Justice Bharta has also relied upon this.
So that judgment has not been quoted here.
My lord?
That judgment is quoted in this order?
Yes, my lord.
Yes.
Which judgment is that? ATS?
My lord,
187.
Kindly bear with me.
Yes.
Prashant Kumar Das. That has been considered by his lordship.
Justice Bharta has recorded
Paragraph 29, my lord.
in paragraph 29, madam.
29, my lord.
No. I'm saying in the recent order, this has not.
11 at page 67.
In the recent order, that has been considered, but if your lordship, my lord, since the recent order passed was much prior to the passing of the judgment in Jaggo versus Union of India and in this matter, so I did
This
not
has
take...
not been considered. This has not been considered.
This has not been considered. This has not been considered. Jaggo has not been considered because all those are subsequent events, my lord.
Yes. Yes.
And if your lordship kindly, my lord, I apologize, my lord.
The petitioner is relied upon an order of division bench such and such. At the time of the appellant was inducted or in service, there was no rules for recruitment of the municipality. There were as such no sanctioned posts or the recruitment of taking permission from any authority to fill up any post. Therefore, the Honorable Division Bench directed inter alia the Principal Secretary in charge of the local body to create sufficient number of posts to absorb 13 appellants. The Principal Secretary Finance Department was to accord the final concurrence. Well, the case was that These appointees were of 1983 to 1985. Much prior to the coming into force of the judgment of Uma Devi. Uma Devi came in 2006. And in Uma Devi, my lord, it has been paragraph 53, it has been clearly stated that cut-off date is for April.
After Uma Devi also there are judgments which have come. And there are judgments where they have relied on para 53 and they have given
that
it
is
those people who have
my
not
lord, that judgment of my lord of the Jharkhand, here the 10 years, cut off 10 years.
Not only Jharkhand, sir, there are other
My lord,
judgments.
in this case, my lord, the judgment of Jharkhand has been relied upon. The Jharkhand judgment is that the Jharkhand state was created
yes,
in 2000. So in 2006, there cannot be any 10 years service.
That we can see, sir. They have given that.
So, my lord, my respect to submission that it is, first of all, it is unsanctioned post. No prior approval from the government as per section 53(4), though the rules came later on. Rules came, my lord, in September 2006. Here the appointment is March 2006. But section 53, subsection 3 of section 54 was prevalent and prior permission was must. Prior permission was must. So that was not complied with. And my lord, in the judgment of my lord Justice Bharadwaj, if your lordship kindly come, paragraph 5.
Yes.
Subsequently, the director of local bodies by letter number has indicated his consent to initiate recruitment procedure of these employment if required. So, director of local bodies has given permission in that case.
Yes.
Notably, no categorical rejection of the petitioner absorption proposal was and there was no proposal for rejection of absorption was there. But here in this case, region or in fact rejecting the claim of the petitioner. That is the difference in the judgment.
Anything else?
My lord, these are mainly 2 points, my lord. The unsanctioned post without following any recruitment procedure, only pick and choose policy. Any recruitment procedure, any procedure that there are interview, 3 persons were called for interview, or that there has been any procedure for recruitment, the selection committee is there, nothing was made, and no permission under subsection 3 of section 54 was taken. These are the main 3 points, my lord.
Yes, Mr. Nag.
I have nothing much to add, my lord.
Add only to the extent that how is this judgment applicable or not applicable to the reasoned order?
Lord, so far as the judgment of Jago is concerned, my lord, which is 2024, my lord, this was not there when the principal secretary considered the case. Similarly, Gautam Kumar Jha, my lord, which has been relied upon, which is the order dated 14th July, that was also not there. So, my lord, admittedly, the principal secretary could not have considered these two. So far as Prashanta Kumar Das is concerned, my lord, the matter there, my lord, will see in paragraph 11 at page 67, there is a consideration by the principal secretary. My lord, what does the principal secretary here says, my lord, if my lord sees? My lord, may I place that paragraph only?
Yes.
It says, the petitioner relied on an order of the Honorable Division Bench, Calcutta High Court, dated 29th January 2018, passed in such and such, Prashanta Kumar Das was the state of West Bengal, wherein 13 petitioner appellants were engaged in between 1983 and 1985. My lord, these appointments of those petitioners there, my lord, it's from 1983 and 85, which is of a time when the municipal act was not there.
Right.
These people who are before my lord seeking the benefit of this particular order, perhaps is not similarly placed with Prashanta Kumar Das, because they are all after the municipal act which came in. And my lord, there was no legitimate expectation. There cannot be any legitimate expectation on their part.
They are similarly situated to Justice Bhardwaj's order.
My lord, whether this, I'm not sure, my lord, whether the appeal has been preferred from that or not, my lord, because it was pointed out before Justice Bhardwaj. Justice Bhardwaj went on to the point, my lord, that as they have continued for a very long period, and there was this order, my lord, so they should get the regularization. But my lord, in that order, my lord, if if I may place the order once again, my lord will see there is a without sounding critical at all, my lord will kindly see paragraph 35 of the order.
Yes.
My lord, I am reading from the I'm reading from the in between, my lord, a sentence starts with the doctrine of equality.
Yes.
My lord, has my lord got it? The doctrine of equality, read in conjunction with the judicially recognized distinction between illegal and irregular appointments, fully supports the regularization of the petitioners in the present factual context, as has already been directed in similarly placed matter by coordinated benches of this honorable court. Accordingly, this court holds that the petitioner's employment is to be regularized with immediate effect. Accordingly, the such and such is disposed of. My lord, the difficulty is perhaps subject to correction by both my learned senior friends, my lord. There is an it is a judgment in ambiguity. And when the matter will be taken up for contempt, my lord, the difficulty will be how this regularization will happen, at what end the regularization shall take place, whether for regularization there will be any post creation or not. The extent which was done in Prashanta Kumar Das, the extent of clearing the judicial mind by the judges while pronouncing Prashanta Kumar Das, my lord, was perhaps cautiously not exercised by the honorable single judge. Honorable single judge granted them some benefit, my lord. I do not know whether my learned senior friend, my lord, was appearing for the petitioners therein, will be able to indicate that whether the regularization has at all taken place or not, and what the state has proceeded with the regularization, because the regularization is not the subject matter of the municipality concern. And my lord, so far as Prashanta Kumar Das is concerned, factually they are not applicable with the petitioners. Their service was under the Municipal Act. And my lord will also see, I had placed perhaps, there was an order, my lord, I am not equipped with right now, there was an order of the coordinate bench of Justice Kaushik Chanda, my lord. In that particular matter, Justice Chanda held that even if you are from the time when the Municipal Act 1993 is not there, you are bound to take approval of the government.
State government.
So there are contradicting views.
Do you have that judgment of Justice Chandu?
This was placed, my lord, by my learned friend before the Honorable Justice Rajarshi Bharadwaj. That was not considered by his lordship.
Not recorded, perhaps.
Not recorded, but it was, he will not deny, I believe. But it was not considered because Prashanta Kumar Das was not placed before his lordship Honorable Justice Kaushik Chand. And there is a paragraph I will place before your lordship when your lordship allows me. It categorically says, the order of the division bench categorically says that when there are no formal recruitment rules, then question of taking approval from the authority does not arise. My lord, that was not, this particular aspect was not considered by the authority while delivering the reasoned order, my lord. If your lordship allows me, I'll place it before your lordship. My learned friend placed the order of the Honorable Justice Kaushik Chand.
My learned
I don't have it.
No,
my lord.
I had placed it before Justice Bharadwaj, which has a contradicting view. My lord, just before my senior friend, my lord, places, my lord will kindly take up the page 67. I would like to place the rest of the paragraphs.
Yes.
Page 11. It says, at the time the appellants were inducted into service, there were no rules for recruitment of the municipality. There were as such no sanctioned posts or the requirement of taking permission from any authority to fill up any post. Therefore, Honorable Division Bench directed inter alia the Principal Secretary in charge of the local bodies to create sufficient number of posts to absorb the 13 appellants. The Principal Secretary, the Department of Finance, was accorded financial concurrence. Well, this was considered. With regard to rules, it was considered. But factually, their position of not having rules and the present petitioner's position of service is not same because of the time gap.
And Justice Bhardwaj also did not consider about the subsection 3 of section 54
of the Bengal Municipal Act.
Of the West Bengal Municipal Act.
And the Bengal Municipal Act.
West Bengal Municipal Act, my lord. That was in vogue in 2000 from 2002. Subsection 3 of section 54.
My lord, if your lordship kindly peruses page 34 of the writ petition, my lord. That is simply internal page. That is part of the judgment of the Honorable Division Bench. Take the case at hand. It is an admitted position that at the time the appellants were inducted into service, there were no rules for recruitment of the municipality. Hence, there were no sanctioned posts or the requirement of taking permission from any authority to fill up any post. None can deny that municipality needed additional hands to discharge their functions by a board resolution of the councillors. For appellants were employed. These persons were also employed, my lord, by a board resolution of the councillors. They were granted a scale of pay and were paid accordingly out of the municipal fund. This is also in case of the petitioners before your lordship. The municipality as well as the public at large enjoyed their services for several years. These petitioners are also continuing till date. Now formal rules have come into place. No employment can be regularized unless they are made to sanction posts. Does that kind of a rule apply to the case at hand? In my opinion, this case is different from the one considered in Uma Devi. It is not a case where there were appointments against unsanctioned posts or appointments beyond the sanction limit without taking the approval of the competent authority. There was neither any rule nor any sanction posts. Rules and sanction posts came later. Now, my lord, if you, I beg to place before your lordship, I concur with the submission with of my learned friends that 54(3) was there of the West Bengal Municipality Act was there, but at the point of time, I don't have it right now, but if your lordship directs me, I'll bring the book. Bengal Municipal Act also had a similar provision. That Bengal Municipal Act was in existence when these persons, before the Honorable Division Bench, they were inducted into service. So absolutely, there were similar provisions. Hope my learned senior friend will not disagree with my submission. Secondly, my lord, if my lord, recruitment rules down. My lord, there are recruitment. If your lordship kindly allows me to place the recruitment. Dada.
Bengal Municipal Act দেখাচ্ছো দিদি?
না না এখন কিছুই দেখাচ্ছি না।
কি দেখাচ্ছো?
What is this?
My lord, kindly, if your lordship kindly sees page 9 of the recruitment rules, my lord. Page 9, my lord. Selection procedure has been drawn categorically. Specifically, there is a selection procedure. And this came into force on 12 September 2006, much after my induction as a casual laborer. My lord, if your lordship kindly sees selection committee in case of direct recruitment or officers. My lord, page 9, if your lordship has found.
Selection committee, yes.
Page 9, my lord. I apologize. Yes, page 9, rule 5. In case of direct recruitment of officers or employees.
This is group B and C, your D.
No, group. I apologize. Sub rule 2 is with regard to group D. In the case of direct recruitment of group D employees, selection of candidates shall be made by a selection committee constituted by the Board of Councillors of the municipality or notified area authority comprising of the chairman of the municipality or notified area authority as the chairperson of the selection committee. 3 councillors to be nominated by the Board of Councillors to be members of the selection committee and 1 representative of the director of local bodies West Bengal who shall not be below the rank of the assistant director and the executive officer and the financier officer of the municipality or notified area authority. After selection of the candidate, prior approval of the state government shall be taken by the municipality or notified area authority before making any appointment directly or on promotion. My humble submission before your lordship, my lord, that is my humble understanding, that is why the Honorable Division Bench as well as Honorable Justice Rajashri Bharadwaj has held that unless and until there are formal rules, these approval cannot be taken. My lord, if your lordship kindly sees
No,
there,
section 54.
স্যার আমাকে বলতে দিন, আমি তো কিছু বলিনি যখন বলেছেন. He is very affectionate to me, my lord. So, my lord, what is my humble submission before your lordship? My lord, in 54(3), my lord, there is no whisper relating how the prior approval, when the prior approval is to be made. Now, when the selection procedure has not been prescribed, that is what is the essence of the Honorable Division Bench's order also. That when there is no selection procedure prescribed, when there are no formal rules, the question of just taking permission from the authority does not and cannot arise. This has been considered. I did not take that, did not trouble your lordship with a reasoned order, my lord, at the outset, because the reasoned order is an even much prior to the passing of this judgment and jagbo. My lord, if your lordship is not satisfied, if your lordship desires that I place before your lordship the jagbo's judgment also, if your lordship directs. I have.
Yes, you have given it. Which paragraph?
My lord, paragraphs, I have relied upon many paragraphs.
Which one?
Paragraph 4, I don't want to bother your lordship with this. They are just they are also.
No, you can read it. Which para 4?
Para 4. The appellants before this, may I, my lord?
Yes.
The appellants before this court, being applicant numbers 1, 2, 3, and 5 before the tribunal, were originally engaged by the Central Water Commission on part-time ad hoc terms. Their case is much weaker than all these persons. They were only part-time employees, and we are casual. Applicant number 1 was appointed as a Safaiwala in 1993, applicant number 2 as a Safaiwala in 1998, and applicant number 3 as a Safaiwala in 1999. All three were primarily responsible for cleaning and maintaining the office premises under the CWC. Applicant number 5, appointed in 2004 as a Khalashi, also discharging duties akin to a Mali or Khalasi, was entrusted with tasks such as gardening, dusting, and other ancillary maintenance work. Throughout their engagement, these individuals performed essential housekeeping and support functions at CWC establishments, including its offices at Faridabad, ensuring daily upkeep and contributing to the smooth functioning of the Commission's administrative operations. If your lordship kindly comes to paragraph 5, initially the appellants sought regularization of their services by filing original application number such and such before the tribunal. They contended that over the years, their roles and responsibilities had evolved beyond the nominal levels of part-time or contractual, and that they were performing ongoing and core functions integral to the CWC's operation. They relied on applicable government instructions and the principle that long-serving employees engaged against work of a perennial nature deserve fair consideration for regularization, provided their appointments were not illegal or clandestine. The tribunal, by its order dated such and such, dismissed the appellant's pleas. It concluded that the appellants were not engaged on what it considered regular vacancies. My lord, kindly, if your lordship takes note of this, that they were also not considered, they were not engaged on what is considered as regular vacancies, not, that they had not completed what it termed as sufficient full-time service, such as meeting a 240 days per year criterion. Rather, these persons have continued for 2 decades, and that their case did not attract the principles of enabling regularization. Within 10 days after dismissal of the original application on such and such, the services of all these individuals were abruptly terminated by the respondent authorities without issuance of any show cause notice. Now, I beg to take your lordship to paragraph 7. After they have filed writ petition before the Honorable High Court over there, they urged the High Court to consider their long and continuous service, the nature of their work, and the lack of any backdoor or illegal entry. They highlighted that they had functioned without any break, performed tasks equivalent to regular employees, and had been assigned duties essential to the regular upkeep, cleanliness, and maintenance of the respondents' offices. The High Court, after examining the tribunal's decision and the submissions advanced, concluded that the petitioners before it were part-time workers who had not been appointed against sanctioned posts, nor had they performed a sufficient duration of full-time service to satisfy the criteria for regularization. It relied on the principle laid down in Secretary State of Karnataka versus Umadevi 3, holding that the petitioners could not claim a vested right to be absorbed or regularized without fulfilling the requisite conditions. The High Court further observed that the petitioners did not possess the minimum educational qualifications. It is not the case over there. They have all the educational qualifications required, ordinarily required for regular appointments, and additionally noted that the employer had subsequently outsourced the relevant housekeeping and maintenance activities, considering that there was no legal basis to grant the relief sought. The High Court dismissed the writ petition. Agreed by the rejection, the appellants have approached this court by way of this appeal. Now, my lord, if your lordship, kindly bear with me, my lord. If your lordship kindly comes to the operative part, my lord, page 19, my lord. I apologize, para 19, my lord. It is evident from the foregoing that the appellant's roles were not only essential but also indistinguishable from those of regular employees. Here also, in case of petitioners before your lordship, it's so. Their sustained contribution over extended periods, coupled with absence of any adverse record, warrant equitable treatment and regularization of services. Denial of this benefit followed by their arbitrary termination amounts to manifest injustice and must be rectified. My lord, they were never discontinued, never. Even after the passing of the reasoned order, they are continuing till date. It is well established that the decision in Umadevi does not intend to penalize employees who have rendered long years of service, fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar versus Union of India, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary but has performed the same duties as performed by the regular employee over a considerable period in the capacity of the regular employee. The relevant paras of this judgment have been reproduced below. The application of the judgment in Umadevi Supra by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and the subsequent circular followed by a selection process. That was their procession of, regarding their promotion. Involving written tests and interviews, which distinguishes their case from the appointments through backdoor entry as discussed in the case of Umadevi. The judgment in the case of Umadevi also distinguished between irregular and illegal appointments, underscoring the importance of considering certain appointments, even if were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedures of regular appointments, such as conduct of written examination or interviews, as in the present case. That is in Vinod Kumar. Now, my lord, from 21, the High Court placed undue emphasis on the initial level of the appellant's engagements and the outsourcing decision taken after their dismissal. Courts must look beyond the surface levels and consider the realities of employment, continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointments. My lord, I pause here for a moment. I beg to place before your lordship there is no whisper till date that there had been any malafide. There had been no challenge to their appointment by any person or any authority whatsoever. In that light, refusing regularization simply because the original terms did not explicitly state so, or because an outsourcing policy was belatedly introduced, would be contrary to principles of fairness and equity. My lord, I beg to take your lordship to para 23 then. The International Labour Organization, ILO, of which India is a founding member, has consistently advocated for employment stability and the fair treatment of workers. The ILO's Multinational Enterprises Declaration encourages companies to provide stable employment and to observe obligations concerning employment stability and social security. It emphasizes that enterprises should assume a leading role in promoting employment security, particularly in contexts where job discontinuation could exacerbate long-term unemployment. The landmark judgment of the United States in the case of Vizcaino versus Microsoft Corporation serves as a pertinent example from the private sector, illustrating the consequences of misclassifying employees to circumvent providing benefits. In this case, Microsoft classified certain workers as independent contractors, thereby denying them employee benefits. The US Court of Appeals from the Ninth Circuit determined that these workers were in fact common law employees and were entitled to the same benefits as regular employees. The court noted that large corporations have increasingly adopted the practice of hiring temporary employees or independent contractors as a means of avoiding payment of employee benefits, thereby increasing their profits. This judgment underscores the principle that the nature of the work performed rather than the label assigned to the worker should determine employment status and the corresponding rights and benefits. It highlights the judiciary's role in rectifying such misclassifications and ensuring that workers receive their treatment. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. Now, my lord, I beg to take your lordship to paragraph 26. While the judgment in Umadevi Supra sought to curtail the practice of backdoor entries and ensure appointments adhered to constitutional principles, it is regrettable that its principles are often interpreted or misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointment. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where their appointments are not illegal but merely lack adherence to procedural formalities. Government departments often cite the judgment in Umadevi Supra to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against the employees who have rendered indispensable services over decades. In light of these considerations, it is in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's functioning, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermines employee morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice and fairness that they are meant to embody. This approach aligns with international standards and sets a positive precedent for the private sector to follow, whereby contributing to the overall betterment of labor practices in the country. In view of the above discussions and findings, the appeals are allowed. The impugned orders passed by the High Court and the tribunal are set aside, and the original application is allowed to the following extent. The termination orders dated such and such are quashed. The appellants shall be taken back on duty forthwith and their services regularized forthwith. However, the appellants shall not be entitled to any pecuniary benefits or back wages. I am also not claiming any back wages for the period they have not worked for, but would be entitled to continuity of services for the said period, and the same would be counted for their post-retirement benefits. There shall be no order as to costs. Now, my lord, I concur with the view of my learned friend that as far as regularization is aspect is concerned, possibly a detailed structure is required to be drawn. That has been drawn, my lord, by the Honorable Division Bench in that case via CAN application. That is at page 39 of my writ petition. Let the third paragraph of the said judgment and order be corrected by deleting the phrase from a date to be decided by the government and replaced by the following: notionally from their respective dates of appointment between such and such, the appellants would be entitled, my lord, paragraph page 39, the appellants would be entitled to pensionary benefits and will have no other claim. This order shall be fully complied with. Apart from regularization, what is my humble submission before your lordship? I undertake on behalf of the petitioner that I will never claim for any back wages, only notional benefit with effect from the date of their initial appointment, my lord, what I pray before your lordship, and pensionary benefits and the scale of pay with effect from the date of passing of the order by your lordship. I concur with the view of my learned friend Mr. Nag that possibly this structure is required to be drawn, my lord, subject to correction by your lordship. And now, my lord, as regards Robindranath, judgment that Robindranath Ghosh, that was considered by the reasoned by the authority while passing the reasoned order, has no applicability in this case. I place a copy of this judgment before your lordship, my lord. Your lordship will find that that is absolutely with regard to labor matters. This has got nothing to do with municipality matters, and that was with regard to 240 days, etc., certain circulars. I do not rely upon those circulars. What I am relying upon is, my lord, that the Honorable Division Bench of this Honorable Court has categorically said that when there is no recruitment rules, the formal recruitment rules, the question of taking permission from an authority does not and cannot arise at all. My appointment, my lord, was much prior to the coming into force of the recruitment rules, and if I have been able to satisfy your lordship with regard to the selection process has also been drawn in the recruitment rules. Unless and until the selection process is over, with regard to 5.2, Rule 5.2, then Rule 5.3 cannot come into force, means cannot come into effect. Rule 5.2 specifically draws who shall be the members of the selection committee, as I have placed before your lordship. And Rule 5.3 thereafter says that after the selection has been done by the selection committee, then only the question of taking approval from the appropriate authority does arise. So that is my humble submission before your lordship. If your lordship wants me to have any solemn queries,
no, let them file their affidavit. Otherwise, this will not.
Yes, we shall file the affidavit. Particularly, subsection 3 of section 54 has not been replied to. And another thing, the judgment of the 24th Supreme Court, that is relating to the irregular appointment. And my case is that here it is the appointment is illegal, unsanctioned post, and without following any recruitment procedure, only pick and choose. Not that the 3 candidates have been selected. Out of 3, he has been selected as the first. Nothing. Only pick and choose. Only pick and choose a person and unsanctioned post. My lord, I will
there is what I beg to place before lordship. There is no, except for the subtle difference that their case in the before Honorable Justice Bharadwaj, their case was once their representation was forwarded. It was not that
So, madam,
partition
now
was
item
granted.
10, so it goes.
My lord.
Item 10 goes.
Item 10, my lord, I have to file
10 goes because if you're not asking for back wages, you're not asking for anything else. You're only.
pensionary benefits. Pensionary benefits are there.
How?
Unless
Pensionary benefits are there.
No, Milord is passing.
Unless it is
I'll have to only yesterday I got the news.
Regarding item 10.
No, our
Petitioner has died. Our stand is petitioner has died.
Died.
And only yesterday I got the news. Unfortunate.
Very unfortunate, but I'm just asking if you are giving up everything except pensionary benefit.
Only pension.
Unless regularization, how the pension benefit will come?
No.
Unless it is regularized.
Place before your lordship, another judgment your lordship gives it. That was a post facto approval was given after the petitioner retired by the same municipality.
So far, my lord, the 24 December 2024 judgment of the Honorable Supreme Court, my lord, has been placed. My lord, it appears from my lord paragraph number 18 and 19 that there was a, my lord, the fact that discrepancy arises that prior to that, in some other states, regularizations have been made. But in this case, so far the petitioners who went to the Honorable Supreme Court after having been losing the High Court, there is that they were not regularized but others. That which discrepancy was, my lord, the factual
discrimination.
Here it is not, number one. Number two, there was no, my lord, the statutory provisions were discussed in that matter, whether year 1993 Municipal Act says that with regard to the, my lord, the appointment in municipality and what has to do, the provisions are there, the mode of, my lord, the recruitment procedure are there. Now, my lord, the only question is that, my lord, that whether their case is illegal or irregular, my learned friend says irregular because of the Supreme Court and the judgment of our High Court recently passed. Now, the judgment of the learned single judge or coordinate bench recently passed, that has not yet been tested by the division bench. We have not yet, my lord, that scope is not yet, but still, my lord, the time is there. Time is there, very recently. So, that has to be tested with the department says that we have to go to the appeal court for the testing of that. Another thing is this, my lord, unless the statutory provisions are being compared, then the irregular or illegality, that two expressions, my lord, cannot be determined. That what is the difference? With regard to the, my lord, the case in hand. If it appears that totally divorce of the law, because the enactment came in 1993, appointment if or engagement, if I can say, after 1993,
2006,
and if it is divorce the provision, then on the face of it, no irregularity but illegality. Now, after that judgment, my lord, of 2004, that judgment, my lord, there are several judgments. In Koras, all judgments say that illegality or irregularity distinction mainly that whether engagement or appointment has been made against a sanctioned post or not.
Sanction
If
post
it
is a
not
main
against
criteria.
sanctioned post, then there are so many judgments, well, at least not less than 12 judgments. I know that after that, Uma Devi, that distinction, my lord, rests almost on this point.
All right, you file your.
I said,
yes.
If you,
My lord, I believe the latest is Jaggo. After that, possibly.
We will see that. We will see that.
Possibly no order has been
The petitioner in the present writ petition is agreed by the impugned order dated 2/11/2021 passed by the Principal Secretary, Department of Urban Development and Municipal Affairs, Government of West Bengal, whereby the petitioner's representation seeking regularization of employment has been rejected. Full stop. This is the second round of litigation. The petitioner, who was a casual employee of the respondent municipality for on a fixed pay scale, on a fixed pay, filed the WPA number, the first one.
My lord, first one is WPA 8319 of 2023. 8319.
Where is it, page?
This matter before your lordship, my lord.
No, the first round of litigation. Where are the details?
First round of litigation, my lord. Kindly bear with me. Dekho na.
This is 7316,
No, that is
right? 7316.
My lord, kindly. 7316, my lord.
7316
of 2021.
Had filed WPA number 7316 of 2021 before this court, seeking regulation of his employment. Full stop. This court, by order dated 27/7/2021, disposed of the said writ petition with a direction to the respondent to decide petitioner's representation in view of the judgment of this court in
My lord.
AST number 242 of 2014. That's right?
My lord.
And other judgments cited by the parties. And other decisions relied upon by the parties. Full stop. This court directed the respondent to examine the aspect of floating a scheme for regularization of casual employees who were working with the respondent for a long time.
That was
as a one-time measure. Full stop. In pursuance of the said directions of this court, the respondent passed the impugned order dated 2/11/2021, rejecting the petitioner's claim for regularization. Full stop. Learned counsel for the respondent state seeks and is granted 4 weeks time. Respondent state as well as respondent municipality seeks and is granted 4 weeks time to file their affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. ये same order in 3, 4, 5, 6, 7, 8, 9 अलग-अलग करना. उसके बाद in item 10, learned counsel for the petitioner states that the petitioner has deceased. Full stop. She seeks and is granted time to implead or take instruction. What?
They have instructed me orally that they'll
implead. All right.
Orally, although.
All right. To implead the legal heirs. Full stop. Necessary steps. She states that she will take necessary steps for the same. Full stop. Let all these matters be.
I believe there will be an application.
Sorry?
Application for substitution.
Obviously. Necessary steps. She has to move an
I'm going to bullet.
I know that
one.
All these matters after 8 weeks. After
May I make one humble prayer before your lordship? Kindly let it be part heard. I believe all my friends will agree, my lord. Because, my lord, once the...
This prayer, my lord, I have exceeded.
Yes, he is exceeded.
I have exceeded.
My lord, kindly let it be part heard, my lord. Kindly, my lord. Otherwise, it's very difficult.
On a lighter note, I don't want to burden my lord.
I also don't want to burden myself.
No, my lord, kindly.
I can read
your lordship has given us, all of us, a patient hearing from the very beginning.
I always give a patient hearing.
That
In all the matters, then I have to make all the matters.
Let it be part heard. My learned senior friend has also acceded to it.
No, I have no problem. I was just on
Reply has also not come. How can I make it part heard?
My lord.
This is just the first date.
After
You'll make my life difficult.
Well, 4 weeks, 2 weeks means after almost after, yes, after
If
vacation.
the reply would have come, I would have made it part heard. But reply also has not come. I can't make it part heard.
So, my lord, kindly grant me liberty to mention so that it can
I'll
come
give a
out.
date. I'll fix a date, a returnable date.
My lord. Deeply obliged.
I'll fix a returnable.
That will be after vacation, I believe.
After vacation.
After vacation.
Absolutely after
vacation.
This would be 12th of November.
12th of November. Deeply obliged.
You can take back the judgments, or I'll keep it.
Let it be, my lord. My lord, in the meantime, although they will not disturb, I believe, in the meantime, let them not disturb their work, my lord. They will not believe, they will not disturb, I believe, though.
Nobody disturbs.
No, no, there is a prayer, sir.
Nobody disturbs. This I've never seen the municipality.
Deeply obliged.
আমার নাম
My lord, on 12th November, my lord, if it can be kept fairly on top of the list. my
That
lord.
I can't.
Deeply obliged, my lord.
Now, if the roster changes,
My
it's
lord.
somewhere at the bench.
That is
Then it's a-
what
then
I am.
it's- Then it's a burden for that bench.
That is what I am.
Hey.
We are all apprehending because we all want the matter to be heard by this honorable bench.
Maybe it's not changed.
All of us. Deeply obliged, my lord.
Except Mr. Nath.
He is comfortable before all benches. Deeply obliged, my lord. No, I don't know.
For the writ petitioner, my lord.
These are all connected matters.
From 11 to item 20.
Yes.
These are all the residential medical officers who were appointed by the municipality.
Yes.
In respect of the post which has been created by the chairman. And since then, my lord,
You filed your reply and all.
reply, my lord, so far as the first matter is concerned. Filing my
Is the pleading complete in all or?
pleading, my lord, so far as item number 20, 19 and 20 are concerned. But no exception has been filed by the municipality in respect of 19
Lord,
and
today
20.
I am filing a report on behalf of the municipality. My lord.
In which case?
In item number 19 and 20.
All right. Let's take one by one.
Even the same, my lord, in respect of 20.
Just one by. Let's take one. So item 11.
Filing my reply to the
11 to 20 are connected, right?
11 to 20 are connected.
So 11. Let's take 11. Let's call out 11. 11 is this. Okay. Yes. Give me.
Filing my reply to the state's exception and to the municipal. I copied the stated exception.
So the pleadings are complete in 11.
Pleadings are complete.
Exception.
State.
Municipality.
Exception to the report filed by the. Exception to the report filed by the petitioner is taken on record. Exception to the report of the municipality and the state filed by the petitioner is taken on record. All right. So this is 11 is complete. Well,
12. Well, I'm filing my reply.
In respect of this is a report in the form of state.
In 12.
Yeah, 12.
The report by the
The
state.
municipality has already filed.
Reply to the reply. Municipal.
A report in the form of affidavit on behalf of respondent number 2 is taken on record. Exception to the report filed by the state as well as the municipality is taken on record. Filed by the petitioner is taken on record. So pleadings are complete in this. 12.
May I submit one thing, my lord?
13.
Both the replies. State and the municipal.
Exception to the report filed by the
municipality, state case
and municipality by the petitioner is taken on record.
It is appearing for the state, my lord, in this matter, probably.
In 13.
13. I want to serve a copy.
13, who's appearing for the state? In item 13.
Last occasion he was here. Vidhan Chandra Mondol.
Ishan Bhattacharya. No, for the state it must be Maushmi, I think.
No,
Santime Bhattacharya.
Maushmi is for the municipality.
Municipality. You are appearing? You are from?
No, he is appearing for the.
For the. So nobody is there, you serve him. Serve him a copy. So item 13 is complete. 14.
14, my lord, state has not yet filed any exception.
Who's appearing for the state?
I'm for the state in item number 18, 17.
14.
No, yes. 14, my lord, state has not filed any exception. Only municipality has filed an exception. This is my reply to the municipality's exception.
Who's appearing for state? Nobody has appeared last time also. Nobody is appearing for the state.
Item number, sorry, Lordship.
Item number 14. 1-4. This is writ petition 16334.
If none appears, my lord, I can appear, my lord, subject to a copy piece of me. I can appear. So hence the same matter, the issue is same. I can appear. No.
Take down. None had appeared for the state on 30/6/2025. Full stop. Today also there is no appearance on behalf of the state. Full stop. Since it's a batch of connected matters, Mr.
AK Sen, HON'BLE Sen.
Mr.
HON'BLE Sen.
HON'BLE Sen, AK Sen. Mr. AK Sen is requested to assist this court in the present writ petition since he is appearing in other item.
My 14 is true. My lord, he has come. 14.
I appear for the
I am ready.
building. Kindly.
Last time also you had not appeared.
I appeared. I am
No.
holding a brief of Mr. Satyajit Mahato. Last time I appeared.
Last time item 30, you were in 13 also?
No, I am in 14.
Only in 14?
Purnima Vishwas. They have not filed any exception. May I file with a copy? Right now, my lord, please.
Okay. At least it's coming. A report on behalf of the respondent number, a report by way of an affidavit filed by respondent number 2 is taken on record. Exception to the report filed by the municipality by the petitioner is taken on. Exception to the report filed by the petitioner is taken on record. Exception to the report of the municipality filed by the petitioner is taken on record. Full stop. Learned counsel for the petitioner seeks and is granted 2 weeks time to file his exception to the report of the state. 40. 15.
Reply to both.
My lord, on for the state respondent.
Only in what item? 15.
Yes, my lord, 15.
The report.
No. My lord, we have already filed the affidavit, my lord.
Stated to?
State.
You have filed it?
Yes, I have already filed it, my lord, and now I'm receiving the reply from the petitioner.
Exception to the report. Petitioner files his exception to the report of the state as well as municipality. The same is taken on record. 15. 16.
I am appealing for the state, my lord. My lord, already report has filed, my lord.
You have filed your report?
Yes, my lord.
The report is filed?
Report is filed, but no exception has been received, my lord.
He is giving it to you. Same karwa, exception to both.
I received it.
Same order as 50. 17.
Direction to file the report by the municipality.
Yes, he is giving.
File the report by the municipality.
Municipality has already filed. Exception is also filed, madam. 17. Yes, 17. Both are filed, right?
Other act of
Same.
Priyadarshi.
municipality copy of the
No, Priyadarshi.
18.
But the 17 probably state is not represented.
It's okay. They have filed it. They have filed it.
I have to serve a copy upon the.
Who's appearing in 17 for state?
Can I serve them, my lord?
You serve them later. D. Mukherjee, S. Chatterjee, K. Bhattacharjee. You serve them in the chambers.
My lord, in 18, my lord, I am for the state. I am filing my report in the form of
Report filed by the report by way of an affidavit filed by the state is taken on record. फिर जो है ना exception to the report of the state and municipality filed by the petitioner is taken on record. 19.
Probably we have filed our reply in the PDF.
You were filing something in 19.
Yes, my lord, the report affidavit on along with the my lord supplementary affidavit, we had inadvertently missed out some facts, my lord.
Give a copy. You are for the municipality.
Actually, 2 weeks time may be given to use an exception.
No, I'm for the
Affidavit on behalf, affidavit and supplementary affidavit on behalf of the municipality, filed by the municipality is taken on record. Full stop. State has already filed?
Yes, my lord, we have filed and they have also filed exception.
Give the copy of the exception. Exception.
I was told, my lord, previous occasion we have filed.
Yes, my lord. 19 already you have filed.
Exception? Exception is not here, sir.
19. My lord, in item number 19, my lord, I believe on the last occasion, the affidavit on behalf, report on behalf of state and exception to that report has been filed.
No, it's just
File tag were kindly given, my lord. That one. What is it?
yes, report has been filed. So this is in 19, then this is only the affidavit in form. A supplementary affidavit is filed, and you with
I will use mine.
petitioner seeks and is granted 2 weeks time to file his exception to the affidavit as well as the supplementary affidavit filed by the respondent municipality. Twenty.
Lordship, I appear for the state. My report is ready. A copy already served. May I file it, Lordship?
This is my Lord, may I file the affidavit on behalf of the ministry along with the supplementary affidavit?
A report filed by the state is taken on record. A report by way of an affidavit and supplementary affidavit filed by the respondent municipality is also taken on record. Learned counsel for the petitioner seeks and is granted
2 weeks time.
2 weeks time to file his report and report to the affidavit and supplementary affidavit filed by the municipality. You have filed your report to the
With the state.
Report exception to the report of the state filed by the petitioner is taken on record.
না দেবে দেবে ও বললো দেবে
দেবে
দেবে ও বললো দেবে
Oh, all right. Now, when do you want these matters?
November. Any date after 2 weeks, my lord, or 3 weeks before vacation.
Before vacation, is it possible? Because almost similar matter. The batch of petition, Lordship fixed it, my lord. That
Because the replies are not there. That's why I fixed it.
my lord,
This one is complete now. We can finish it off.
Yes, my lord, Lordship kindly.
Let's finish it off.
We leave it to you. Convenience time, according to my
Let's finish it off.
according to your Lordship.
9th September?
Yes,
9th September. August, yes. Yes, yes. 9th September কি বার পড়ছে?
We have a lot of time. We'll finish it off.
Only, my lord, except 9, 10, 11, any day.
10th September?
10th September. My lord.
10th September. 10th September.
10th September.
After 2 weeks. 10, all matters. Yes.
Item number 12 and 18, last location 30th July appeared before a lordship, but not my appearance is not recorded. In respect of item number 12 and 18. 12 and 18. Last occasion I appeared before a lordship, but by non-record not recorded.
September. Grateful.
Grateful.
This is a very good system that there are a bunch of petitions. So let it be ascertained first that pleadings are complete. Then matter can be taken up.
We can just finish it off then.
Yes, grateful.
Great.
21, 22, 23, all are similar matters.
21 is different, my lord. And the 22 to onwards, 33 same. But 21 is different.
Who's appearing?
In fact, my lord, last occasion, my lord, Lionel Pen, my lord, file, my lord, opposition, my lord, and this is my reply, my lord.
Not sure I am filing the opposition.
Yes.
Take that. Affidavit. Affidavit in opposition filed by the respondent number 2 is taken on record. Exception to the affidavit, reply to the affidavit on record is also taken on record. Reply filed by the petitioner to the affidavit in opposition is also taken on record. Place this matter for hearing on September. 16 September will hear for hearing. For hearing on 16 September. Readings are complete, we'll keep it for hearing. The rest of the matters tomorrow.
My lord, matter will appear under the heading of motion.
Yeah. What? Hearing. Why?
No.
We are giving a date, it will be heard. The rest of the matters tomorrow.
Well, 22 to 16. Similar matter. Pension matter. Tomorrow.
I have lot of judgments also to pronounce all pension matters.
3 matters.
3 bunch different, not 3 matters. 3 matters are 11 judgments are there.
My matters are 3 matters.
And 41 may I come back day after tomorrow?
Why?
Will not be there tomorrow.
40, 41.
I'll inform Mr.
You're for
I'm for the petition. I will inform Mr.
Day after
40 or 41.
40 and 40. Great.